Pledge of Allegiance, please.
Happy to.
Everybody
Thank you.
stand.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. And again, proper notice has been given as required by the Ohio Revised Code 121.22. And we're going to begin our meeting today with approval of the board meeting minutes from March the 2nd, 2021. And everyone, the board should have received their minutes and reviewed them.
Yeah, I reviewed them, and I also know there was a transcript. The only reason I note that for today's transcript and meeting minutes is much of what occurred last time is the subject of litigation, so the minutes will incorporate the transcript as well, correct?
That's correct.
Yep, so with that, then I'll move approval of the board meeting minutes from our March 2nd meeting.
Okay, any more discussion? All those in favor? Aye. Anyone opposed? Anyone abstaining? That motion carries. Thank you very much. Next, and we're going to adhere to our agenda today. We're going to next move to review and discuss insufficient Cincinnati mayoral candidate petitions. And we're going to look at these mayoral petitions that have been filed by two individuals, Adam Kaler and Kelly Prater. And I'm going to turn it over to Ms. Poland. Could you begin the discussion, please? And this is a protest hearing regarding, first, Adam Kaler.
Yes, a copy of the protest was circulated to the board members, and a copy is also in your packet. Staff has had the opportunity to review the objections raised in the protest regarding Mr. Kaler. And in your packet, you have a brief summary that staff produced in regards to the protest. Letter A, circulators not need be City of Cincinnati registered electors. Just to remind the board, on staff's initial review of these petitions, staff found 439 valid signatures on the petitions filed. There's an additional 17 signatures on part petitions that were circulated by circulators who may not live in the city or do not live in the city of Cincinnati. And we are asking for legal guidance on whether or not those 17 signatures can be validated.
Okay, and I'd also like to state that the candidates and their counsel are reminded that pursuant to the Ohio law, the board cannot accept or consider evidence that constitutes an alteration, correction, or addition to their petitions or any of the part petitions that they have filed. And this is in relationship to Revised Code 3501.38-1. So, are there any changes in the staff report?
Yes, just to begin with, the 17 signatures, we're looking for legal guidance on whether or not those 17 signatures can be deemed valid because they were circulated by someone that lives outside of the city of Cincinnati, and that does appear to be a requirement of their charter, but there may be case law, I believe, that may say otherwise. So that's why we're looking for guidance from our legal counsel.
Okay, so is Mr. Kohler present? Or legal counsel, I'm sorry.
Yeah, we need to finish her report before we do
please
that.
finish.
And
I'm
that's-
sorry.
And the question that was asked by Ms. Poland regarding the 17 signatures that are on, that were circulated by a citizen who is not a resident of the city of Cincinnati. It is true that the charter requires that petition circulators be residents of the city of Cincinnati. We asked the city solicitor's office for some guidance on that. They sent a letter over prior to our meeting on March the 2nd that dealt with that. And their comment was, is they're aware of the cases that have struck down state laws that require the residency of circulators for state petitions, but that the requirement is still in their charter. I am not comfortable defending that position. I think that the Sixth Circuit Court of Appeals for the United States Federal Court of Appeals has said that circulator residency requirements are not acceptable, and state law has been changed in that regard since that decision came out. And I think that the 17 that are on the petitions that were circulated by non-resident circulators should be counted.
Okay,
That's my opinion.
And I, by the way, I also read the letter from the solicitor, Mr. Garth. He's not present, is he, Andrew Garth? There is somebody from the city, though. Did you wish to address this at all? Not to take, but
Go
just,
ahead.
since we're on this topic.
since we're on that topic.
Did you wish to address this question? I know you're here on another question, right?
Unless you have questions specifically for us, the letter really outlines our understanding.
Okay,
So,
very good. But thank you for that. And your name for the record, we didn't,
oh, my apologies, Emily Smart Warner,
thank
And
you.
your position?
Deputy City Solicitor.
Thank you, for the city of Cincinnati.
Thank you. So your position is the 17 should be added to the original count?
I think that's correct, and,
Okay.
and whether that provision is struck down later or is removed from the charter at some point is something that's beyond our purview here.
Okay.
But I think that if the matter were litigated, we would be told by either the Court of Appeals or the Supreme Court that we should include those. So
Okay.
I think that that's what we should do.
I agree. Thank you.
That would bring the total number of valid signatures to 456. Staff reviewed the other portions of the protest filed, and we are in agreement that 4 additional signatures should be, we now found to be valid. 3 of the 4 were simply that staff was unable to read the voters' names. It was illegible. But now that we've been supplied with the voters' names, we can confirm that they are registered voters, and recommend those 3 should be accepted. And there was 1 additional that was a counting error, and so that would bring us to 4 more being added. So staff recommendation is the petition contains 460 valid signatures.
A total?
Yes.
Okay.
May I, Madam Chair?
Yes,
Yep,
go
so
ahead.
at that point, the rest of the current position of the board, before we hear from council and from Mr. Kaler and any evidence that they want to present, at this point, we're recommending that he is short at this juncture,
That's correct.
subject to
Yes.
the board's review.
Absolutely.
Okay.
Thank you for that point of clarification, because I was going to bring that up myself. So thank you. Okay. So, moving on, is Mr. Kaler present? Mr. Kaler, can you step to the microphone, please?
I think he's
And
actually
are you represented by council as well? And I need the council person to please, if you can give us your name for the record.
Sure. Is it okay if I take the mask off?
Sure.
Yes, you're safe from me.
Oh, sorry about that. My name is Donald Bry, B-R-E-Y. I'm a lawyer with Isaac Wiles in Columbus,
Okay.
on behalf of Adam Kaler.
So I would like to hear from Mr. Kaler first and then from you, sir, if you don't mind. Thank you.
So you guys might have seen me up here.
Can you speak into the microphone? 'Cause
Sure.
There
Can
we
you guys-
go.
there we go. So I've done a tremendous amount of work, I think, outside of just getting the signatures, and finding people who, finding those 4 valid signatures. And then in addition to that, I believe we have another 23 signatures that are from registered voters in Cincinnati, where I actually have their current address, where the board actually has their past address. And outside of that, we have 36 other signatures that my counsel will make a case for today. So, and looking forward to your decision, and I appreciate you guys giving us the time to actually come up here and serve the city. So I'm looking forward to that.
Thank you. Thank you. Did we need to swear him in? Mr. Kaler? Yeah. Do we, I think we should.
If he's going to offer evidence, he needs to be sworn, yes.
Yes, please, could you swear
I
him
mean,
in, please?
what we have right now is a statement so far.
Thank you.
Just to be clear, I would suggest nothing that he said in his introductory remarks would qualify as testimony and evidentiary. in
I
nature.
agree, that was
Yeah.
just a statement.
So,
Okay, thank you. Mr. Grime, please.
Thank you. With the permission of the,
Could you speak a little closer to the microphone? We're just, and you're welcome to remove your
It's
mask
a strange
for
new
just
world.
this, yes.
with the permission of the chair and the staff, I'd like to pass out 5 documents. And I understand I should give those to the,
You're intending to admit
And those
them.
are considered evidence that constitute an alteration or correction, is that correct?
No.
Okay.
Not at all. As a matter of fact, 4 of them are demonstrative and only summarize documents that are already in the possession of the board.
Okay,
The 5th one actually attaches some of the 3-part petitions where the circulator's date was wrong and has an affidavit saying, yeah, I really signed this, and they were all there. I believe you have the original.
excuse me, just a moment.
Can we have a
Mr.
mark,
Stevens.
please?
Yes.
Yeah.
Can I, the old judge in me is freaking out a little bit because of the way it's all kind of going. So can we just let her mark it, because she can't take anything down while we're talking, and then Deb has to take minutes at the same time. So maybe we can just give them a minute to mark it before we continue.
Good point.
With all respect, Madam
Good
Chair,
point.
just
That's
having.
fine.
That's the original. Each paper in the folder is identical. I have, I think, probably 9 or 10 copies of each one of them. Well, there are, the clip things in each folder, I have 9 or 10 copies of exactly the same document.
Yeah, so what you have is you have several exhibits and you have copies of those.
Correct.
All right.
It occurred to me that waving it at you might not be the most useful from your perspective, or mine.
So in essence, what you just said, counsel, he had 7.
Gwen, with all respect, she can't write down what you say, and to the extent that we
Oh,
ever
okay.
litigate,
Okay.
anything you ask him right now is not making its way into the record. So
Okay.
frankly, this board should be silent until
Silent.
that court reporter speaks again.
Gotcha. Okay. Thank you.
Sure. Thank you.
Thank you. I got B. C?
What's that?
Is there a C?
This is B.
I got B, A and B.
I have B.
Okay, just check.
Those are the
You
originals.
actually have copies of those affidavits. Those are the originals, because we need to file an original. You have copies, but they're 8.5 by 11 rather than 8.5 by 14.
Okay, okay.
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 Trying to know what the letters are. A, B,
Let's see.
D, I think. D.
Thought we had D. Oh, this is E.
C is the charter, D is the, this.
Gotcha.
Yeah, it's D, Chip. Yeah, we got A, B, C, D, E so
Yeah.
far.
Mm-hmm.
Which should be all of them.
That's 1, 2, 3, 4.
Yeah, I got
1,
what
2,
you need.
3, 4, 5.
You ready, Barb? Sorry, Madam Chair, go
Okay.
ahead.
If you can continue, please.
Thank you, Madam Chairman. I apologize for the delay on that. I hopefully am going to do this in a way that expedites matters rather than slows them down. At least that's the attempt. There are, as you may have noted, 3 main areas that need to be examined to determine whether or not Mr. Kaler has enough petitions or signatures on his petitions to be certified to the ballot. The first one has already been dealt with, I believe, which is Exhibit A. There are 17 signatures that were circulated on part petitions by out-of-state circulators. We agree with the finding that those should be counted and agree that Nader v. Blackwell, the Sixth Circuit case alluded to by your counsel, controls. Secondly, there, in Exhibit B of the packet, there are another 3-part petitions, which according to staff have, I believe, 36 additional valid signatures if they were to be counted, that were rejected because the circulator's statement is dated, the date that the part petitions were delivered to the circulator rather than the date that the circulator signed the circulator's statement. And the directive of the Secretary of State in the, I think it's Chapter 11, pages 11-7 of the manual for the election board officials, states that whether circulator statement is required to obtain, which of course is summarized in the statute, 3501.38. And in neither case, neither in the Secretary of State's directive nor in 3501.38 is there a requirement that there be a date on a circulator's statement. Of course, as I will suggest, 3501.38 doesn't control. This is a charter city. The charter city has indicated what its part petitions are supposed to look like when you have mayor petitions, and what they say controls, not 3501.38 about the form and how you determine the sufficiency of the petition. And they do have a space.
Can you speak into the microphone just a little bit, please?
I
Because we wanna make sure
apologize.
We want to make sure we hear every word that you state.
Well, I'd like that too, and I apologize for making that less possible than it should have been. Maybe I needed more caffeine before I came in here.
No, it's the microphone.
Of course, in that case, I would be speaking too quickly for you to hear me. We were talking about the misdated circulator statements, and you have those in Exhibit B along with an affidavit with respect to those 3 part petitions saying, you know, I witnessed all these signatures and signed them after they were signed, but I misdated it. And you will note that the date is prior to or on the same date as the first signature on each of these part petitions. The reason seems to me, from the face of it, that they signed a date when they received the part petition, which is something truckers often do. And I understand one of these individuals does that with shipping and delivery. When they receive a sheet, they date when they received it. And the question is, does that void these part petitions or not? The requirement to have a date is not in the Ohio Revised Code, 3501.38. And it is not in a directive from the Secretary of State. It is on the form, and even though the Ohio Revised Code doesn't require it, I would agree that the Ohio Revised Code does not control. This is a charter city which has provisions in its charter about what its forms should or should not look like. And anything dealing with the sufficiency of the form or the signatures on the petition of the sufficiency of a form for a mayor candidate for a charter city like Cincinnati has to follow the charter instead of the revised code where the charter speaks about the form. And in Section 3 of Article 9 of the Cincinnati Charter, which I've provided that chapter in Exhibit C, so you've got it, basically defines what the part petitions are supposed to look like. I think Section 2 says they have to be signed by people who are electors of Cincinnati. You know, those are the signatures that count. But Section 3 says it shall be substantially in the following form. And at the end of Section 3, it does have a list for date after the circulator statement. It does not state whether that's the date the circulator received it or the date the circulator signed it. It just has a statement of date. But more importantly, the very first sentence of Section 3 of Article 9 of Cincinnati's charter says that the part petition shall be substantially in the following form. And a mistake in a date is not something, frankly, even if you were dealing with 3501.38, which we're not, should void a signature or a petition statement. And the authority for that is the Ohio Secretary of State's tie-breaking vote of February 24 this year, just a couple weeks ago. There was a disagreement about whether or not a signature, not a circulator statement, but a signature should be thrown out because it was dated in 1 January rather than 2 February, or maybe it was the other way around. It was dated 2 February, and February hadn't happened yet, so they threw it out because there was a mistake in the part petition, or at least 2 of the members of the board voted to throw it out. The other 2 voted to uphold it, and the Secretary of State had to break that tie. And the Secretary of State broke that tie in favor of allowing them on the ballot, saying that minor mistakes like that shouldn't throw somebody off of the ballot. And we talked about that in our petition that we filed, our protest document that we filed last Friday. That's part of what we discuss in there, and we quote the Secretary of State's reasoning in connection with that. So we think that it is clear that if you are, frankly, this was even in a strict compliance statute that the Secretary of State was construing, but certainly in a substantial compliance statute, a minor mistake in a date should not toss out a petition, because this board is well aware the Ohio Supreme Court over and over and over again, and the Secretary of State over and over and over again, have said when boards of elections have discretion about whether or not to throw somebody off the ballot and deprive the voters of a choice, or discretion to put them on the ballot and give the voters of a choice, they have a duty, a mandamusable duty, to put them on the ballot and give the voters a choice. And since we're dealing with a substantial compliance provision of the charter, you don't even have to go about into the inquiry whether or not a strict compliance statute would be construed the same way, although it looks like the Secretary of State would construe it that way, because that's what he did just a couple weeks ago.
Counsel, can I interrupt just for a second?
Please do.
I'm not familiar with that 2-2 vote. I'm glad you brought it up. Can you clarify again what issue was that? What was that issue in that 2-2 tie vote?
Yeah. The Pickaway County Board of Elections had a tie vote involving a mistake in which 4 signers of the part petition mistakenly signed a date after the date appearing in the circulator's statement.
Okay.
And 2 of the members of the Board of Election voted to take them off the ballot, and 2 of the members of the Board of Election voted to put them on the ballot, which required the Secretary of State to break that tie. And the Secretary of State noted, as I alluded, that the Ohio Supreme Court has long held that absolute compliance with every technicality should not be required in order to constitute substantial compliance, unless such complete and absolute conformance to each technical requirement of the printed form serves a public interest and a public purpose.
Thank you, okay.
And, also that the public policy favors free competitive elections in which the elector has the opportunity to decide their candidate of choice. And here, Secretary of State is not giving his own opinion, he's quoting the Ohio Supreme Court, because those words came from Ohio Supreme Court decisions. And he said that since mistakenly writing down dates that haven't occurred yet, a 1 or a 2 versus for January, or 2 instead of a 1, or a 1 after the 2, the signers of the candidate petitions made a technical mistake. There's no claim of fraud or deception, and there's sufficient substantial compliance to determine the petitions to be valid. That was the reasoning of the Secretary of State in that pick-away 2-2 tie vote.
Thank you.
Can I interrupt for a minute?
How about, yes, Mr. Stevens.
Yeah, with the directive that broke the 2-2 tie, am I correct on this, Mr. Bry, that the dates that were written by the voters, and it wasn't the candidate and it wasn't the circulator, the dates that were written by the voters were dates that had not occurred yet, correct?
They were written by the voters after the date of the circulator statement, yes. I think there were dates that hadn't occurred yet. I think in one case they put 1-2 for 12
All right,
instead of 1.
so-
In one case they put 2 for 1.
So essentially, the petitions were submitted before the dates that the voters had written on the petition form. So it wasn't the date of the circulator and it wasn't the date of the candidate that was at issue here.
Well, I believe that's partially true. I think that certainly was true with respect to, I think there were like 3 signatures. And I think one of them, was certainly true, that they'd written the dates before the petitions were filed, so they couldn't, it was impossible. And I'm not sure about the 2 versus the 1. There was one case in which somebody wrote 2 for February rather than 1 for January, and I don't recall whether the petitions had been submitted before that February date or after that. I'm sorry, I just don't recall.
So that citation that you just shared with us, that's in which one of these documents?
Unfortunately, I didn't provide in the document.
I have a copy of the
if you'd like
directive.
it.
If we need to
Please.
make copies of it, I've got a copy of it here.
Okay.
It's also available on the Secretary of State's website. But in any event, I mean, even apart from that, it's clear that putting down a date that by the circulator in which he received the petitions is a technical mistake. If the intent was, by the way, this is just an intent argument because there's no language in any statute or even in the charter saying the date means the date you signed the circulator statement. It says date. It doesn't say what date. It doesn't say, there's nothing in the statute and there's nothing in the Cincinnati charter that says the date that you put down under date must be the date that you sign your circulator statement. It just says date. These people most people understand that to mean when you sign the circulator statement. We all understand that that's what is intended, but it's not what's said in the law. What's said in the law is date substantially. And we had 3 people or 3-part petitions that construed that as saying the date I received the part petition in my hands, I'm going to write that down as the date. And we would say that's not how we do things here. Well, it's not how we do things here. But it doesn't mean that that's what the law requires. It doesn't mean that we have no discretion about looking at that and say they made a technical mistake. They should have done it like everybody else does. But they haven't actually violated any statute. They haven't actually violated anything in the Cincinnati charter. And even if they had, Cincinnati charter only requires substantial compliance. And substantial requirements means that if you make a technical mistake, like a date, that's enough. I will agree with you, by the way. I asked the Secretary of State's office. They have not found any authority construing one way or another date mistakes in the circulator statement. But I think the argument and the rationale would still stand for that.
Can I ask
Yes,
Can
Mr.
I ask
Stevenson.
another question? Mr. Bride, you submitted these affidavits which appear to correct the impression that's given by the petition that was filed by the circulator and by the candidate with respect to the signatures. Can you tell the board, please, why this is not a correction or addition to the petition?
Well, we're not correcting anything. The petitions themselves state that the circulators witnessed all the signatures. And they signed a statement that they witnessed all the signatures. The question is, was this a technical mistake or not? Well, yes, it was a mistake. But to the extent that you have any question about well, maybe they signed it without witnessing any of them? I mean, first of all, that's not reasonable. Or maybe they signed it, say I witnessed 27, but they signed it on the 7th of January when only 5 had been written on the 7th of January. That is not a reasonable way of viewing what the circulator statement said. I mean, I understand the argument, are you correcting or not? You know, what we are doing is trying to alleviate any question about, you know, what that number meant.
So there's no evidence, the evidence that you have suggested or submitting, you're saying does not consider any evidence that constitutes or alteration of a correction or addition to what you've already had? Is that what you're saying?
We're not correcting anything because there was no misstatement. He did receive the part petitions on the dates he wrote down. It's just the dates he wrote down were not the dates
Were
that he
not the
signed.
correct dates.
Well, how do you say correct? By whose standard? Not by the statutory standard and not by the standard of the code. Correct means there is an authority that says you write down the date you sign the signature, and there's nothing in the law that says that. Nothing. And so I would say they did not do the correct date. I would agree with you. It was an incorrect date by the way that anybody who is experienced in politics and pass out petitions. That's not the way we do things. You know, I understand that. But it's not incorrect if you're saying, does this contradict a statute or does it contradict the charter of Cincinnati to write down as under date, the date you receive it, rather than the date you sign it. And I would say it's not incorrect that way. It's unusual. It's not how I would tell people to do it. It's not how we are used to it being done. But there's nothing in the law that requires it. And therefore, you can't say it's incorrect just because it's unusual.
When you say just because it's unusual, if it's not according to the guidelines, that's not unusual, that's an error.
Which guidelines?
The ones that we follow as a board.
Right. You follow the guidelines of the Secretary of State in the manual he gives to boards. You can look through those guidelines and you will find no reference in the Secretary of State's guidelines to a circulator statement having a date in it. Matter of fact, I alluded to the pages in the guidelines of the Secretary of State that you follow, which list what a circulator statement has to have, and in no place in there does it say a circulator statement has to have a date. It says signers have to have dates. The statute says that too, but it doesn't say a circulator has to have a date.
But the charter does, correct?
But the charter does not say it has to have a date. The charter says that the form includes date after the circulator statement. You're correct. And I would agree the charter, rather than 3501.3, in control. I mean, I'm not disputing that. But I would dispute the notion that an incorrect date fails to substantially comply with the charter. And I would rely upon, yes, it's dealing with signatures, misdatings, rather than dealing with a circulator statement's misdating. But I would rely upon the tie vote of the Secretary of State saying that such technical mistakes in writing down a date shouldn't toss a petition if substantial compliance is the standard.
Mr. Brewer, I think I'm going to ask Mr. Stevenson's question just a slightly different way. And the 350138I1 plainly says no alterations, corrections. So it's your position that the affidavit is not a correction, even though it admits an error, does it not, by the circulator? I mean, essentially the last sentence of the affidavit says, my initial declaration was made so in error. Word error and correction tend to go together in the English language. I'm not being flip about it. I'm actually,
Right.
I'm fairly intrigued by your presentation, candidly, so that's why I asked the question. But I would like for you, on the record, to tell us why the suggestion that it's made an error in the affidavit isn't a correction that would be prohibited under the statute. That's my question.
Well, the exception to technical stuff, there's a couple, but one of them is there evidence of fraud or of some sort. And basically he's saying, I don't think there's been any evidence presented that he fraudulently wrote down the wrong date. But to the extent that suspicion were out there, which is outside, it would require something outside of the four squares of what you have in front of you. And the main purpose of the affidavit is to say we weren't engaging in fraud, we just made a mistake.
Yep.
And
Thank you.
mistake in the sense of this is not how it's done, not mistake in the sense of this violates the law.
That certainly answers my question. Thank you.
Will you continue, please?
But please interrupt me anytime you want to, because it's easier for me to answer questions that I know you have than answer questions you don't have and don't want to hear me answer. This brings us up, if my math is right, 460 plus 36 gives us 496, or 4 short of the goal of 500. The,
Excuse me, Madam Chair.
Yes.
Mr. Bride, just a question of the, and maybe this is a question for the staff. The signatures on these two part petitions after the date that they were signed, have they been checked for validity?
We did a cursory review. We did not process them through the module, but we found that 36 would be valid.
Okay, all right, thank you. Sorry, I just
no.
trying to keep my math straight here.
Well, actually, it's helpful for me to have that on the record, too. So 36 plus 460 gets 596. We need 500. And that leads us to the third main argument. You have in Exhibit D, I believe, a summary of signatures that match on the Board of Elections website. And there are I think we're looking at the same. Let me make sure that.
Are we looking at D, or which one are you?
D, is this what it
This
looks
one.
like? Okay, good. Then we're both looking at the same thing, which is helpful. Exhibit D summarizes signatures that match the Board of Elections addresses as of today. Now, a couple of these were changed from the date of the filing, and you will note, as I'm sure your counsel will point out, that 3501.38 states that the address should be the same as that they signed as the address on record with the Board of Elections as of the date of filing. Some of these were, and that may have been the 3 that they caught, and some of these are not. But the signatures all match, and all of the addresses show them to be qualified electors in the city of Cincinnati as of today, and frankly, as of the date they filed, if the addresses of the petition were accurate. And that raises the question, you know, and there are also a couple that I think have this, there are 3 more, I believe, that have the correct street address, but don't indicate the number. No, I guess there are 2 of those, and there are 3 that have the same street, but the wrong number. And again, we're looking for 4 more out of these. There are also 17 others, and you have them all delineated in Exhibit E. Exhibit E goes through all the 27 disputed signatures that we're raising issues about. Some of them clearly have different addresses. Both addresses show them to be an elector within the city of Hamilton County, well, city of Cincinnati in Hamilton County. But
Madam Chair, I have a question.
Yes, Mr. Mel.
So, sir, would you consider this an alteration since the address was updated with a new registration form from the date that the person originally signed the petition?
no, I would not. I'm actually presenting in an abbreviated form records that the board already has. The board has the records of the part petitions. I pulled out the signatures at issue, so you don't have to go through all, I don't know how many part petitions there are, and I pulled out what we have as of record with the Board of Elections today. The question is, according to the charter of Cincinnati, the requirement is not that you have your address be the same, but you are qualified to vote. You are a registered elector. These folks were registered electors. They are registered electors. At the time they signed, they were qualified to vote. There's no requirement in Article 9, Section 3, that the address be identical to the address at the Board of Elections as of the time they filed. That's in 350138. But we've just been talking about how 350138 does not prevail over a charter. Matter of fact, the Ohio Supreme Court has said that too several times.
Mr.
Well,
Bright,
yes, Mr. Steves, I'm so glad. Go ahead.
Mr. Bright, with respect to that question, are you saying that the charter is silent with respect to that?
I am not. I'm saying the charter speaks with respect to that.
You're saying that they're qualified voters, but with respect to the number and the name and the address that's on file with the board on the day the petition is filed, the charter is silent?
I don't think the charter is silent at all.
All right, well,
I think, well, the charter doesn't specify that you have to do that. The charter establishes, here's what we have. Let's take a look at Exhibit C, which is copy of the chart. On Section 1, and this is the portion of the charter that deals with municipal elections. It says, all elections provided for by this charter, which would include this one, shall be conducted by the election authorities, this board, prescribed by general laws, and the provisions of the general election laws of the state shall apply to all such elections, except as provision is otherwise made by this charter. Now, a couple questions. It talks about the conduct of elections. The Ohio Supreme Court in Blackman v. Height, it's a 5 Ohio State 3rd 156, 1983 case dealing with a recall petition, not a candidate petition. But what it did say is that home rule municipalities are governed by their home rule and not by the general law. And it also suggested that saying that the general law applies with respect to the conduct of elections is not the same thing as saying that general law applies with respect to the nature and validity of the petition. They say it in passing, it's over to dictum, it's not res judicata, but they do say it. I'm not just coming up with this idea. And the elections provided for by this charter, except as otherwise made for by this charter, well, what do they say? Do they say in Section 2, any person eligible may be placed in nomination signed by 500 electors. Each signer of the petition shall sign his or her name, address, and date of signing in ink or indelible pencil. By the way, here it says that the signer is supposed to sign the date of signing. There's nothing about the circulator shall sign the date of signing the circulation papers. All right? So that's one distinction. And, the requirement in 3501.38 is superseded by the requirement of Article 9, Section 2, about who you're looking to file. In other words, if you are a qualified elector, you can sign. Not if you are a qualified elector who has moved and updated, they're moving here with the Board of Elections. And that's a distinction. The other thing that I would point out, in Section 3, remember, the conduct of the election, general law. But the form of the petition, in other words, the validity of the petition, is governed by Section 3 of Article 9 of the Cincinnati Charter. And
actually, it's Section 3A for mayor, and that's not included in your exhibit, but we've been dealing with that for the last couple of weeks. That's just a mistake.
I'm sorry. I thought I printed everything out, and I didn't see 3A.
Mr. Bry, it's on the, just so you know, the website was not updated at American Legal or wherever you got that. That's the problem.
Well,
And
Thank you for that point of clarification,
Well,
because I was
I
getting
appreciate
confused
that.
as well.
Yeah, it's 3 deals with council petitions, 3A deals with mayor petitions.
do they also have substantially as follows in 3A?
It's exactly the same.
Okay, well, that makes me feel a little better, even though I've given you everything except for the form that talks about the form for the mayor in here, and I apologize for that.
I don't know whether I have it for you, but we can.
Well, that's right. I think I can make the argument without that.
Sure.
I understand that Section 3A is a lot like Section 3, and both of them say the form of the nominating petition paper shall be substantially as follows, and the form, again, substantially means if there are mistakes in this, such as you didn't write in the numbers of your street. You wrote in the street, but not the numbers. Such as you didn't update it until after it was filed. All of these are relevant only if you weren't an elector and you are now. But remember, we all are familiar that when somebody moves and hasn't updated their registration, they can still vote. They can show up at the primary, make a registration change in their address right then and there.
But then they would vote provisional.
They would vote provisionally, but voting provisionally doesn't mean you're not an elector. Yes, you would vote provisionally, but you would vote as an elector. And what did they do? They did this after the deadline to register as a voter. In other words, they do this up to the date of the primary. Are they an elector? Yes, they're an elector. Did they move? Yes. Is their address that they have on file their address today? No. But that's why it's important when you focus on, are they an elector? Were they an elector? Are they someone with the capacity to vote for or against candidates for Cincinnati mayor in the primary? And if you are, then you have substantially complied with this. And if you're not, then you haven't.
Help me with this.
Yeah.
If a person signs a petition, or even, and they're not at the correct address or does not have the correct name at the time of that petition, when they sign, my understanding has been, and Mr. Stevenson, correct me if I'm wrong, that therefore that is not valid, that signature is not valid.
I believe that's a correct statement of state law, yes.
Thank you.
Remember what he said, a correct statement of state law. And by the way, I would ask you to take another look at, for example, someone says Ted Adams instead of James E. Edwards Adams. I believe the Secretary of State's advice is you count that signature. You know, in other words, you use derivations of a signature. They don't have to be exact. There is a 20-year-old case, and I think your counsel may have been alluding to that, where someone said, well, they have these are not the right names. You have an Alice Walker and you have an Alice Walker Jones, both at the same address, but they might be different people. And therefore, the board in that case had a rejection upheld by I think it was Supreme Court mandamus, because that you can't know from that alone that they're the same person. However, you have the signatures. The signatures match exactly. Whether you're talking about I think there are 2 or 3 people who got married. You could take a look at them, and I think that's mostly in Exhibit E rather than Exhibit D, where they have different names they've moved, but you can match the writing, the handwriting, and know with certainty that these aren't 2 different people signing their name. They're the same person signing 2 different versions of their name. Again, it depends upon how deep you want to go into the weeds. As I
Mr.
said,
Bright,
we're down by 4, so we don't need to win all 27.
If you said this, I missed it. So you're suggesting obviously all 12 of these on Exhibit D are now updated in our system? Do you know how that happened?
I believe that 9 of them are updated and 3 of them are not. Are they all updated? I think the first 9 are updated. The remaining 3 are on your system with the same street, and were with the same street but a different address. So those have not been updated.
Well, and I have a question about this number 1 on D, that signature, they do not seem to match at all. Plus, it seems like maybe the address wasn't correct.
Madam Chair, if I could help the board. In this Exhibit D, the first 3 signatures, so voters number 1, 2, and 3, those are the 3 voters that, after board reviewed Mr. Kaler's protest, agree that those 3 should have been accepted initially. So they were already included in the 460 count that staff spoke of
Okay.
at the beginning of the protest hearing.
Oh, okay.
So on all 3 of those, staff, based on the signature, was not able in the initial review to determine the name of the voter. After receiving the name of the voter, then we were able to locate the voter in the system, match the signature and the address. So the first 3 were included in the board's revised count of 460.
Okay, gotcha.
That
Thank
leaves us
you.
with 9 additional. And
so
Sherry,
that-
real quick, while you've got the floor, the other 9, those, again, just backing up, and maybe this has been covered, but there's so much flowing at us. Those 9 were rejected. Why? For signature purposes or because of the address?
I think we'd have to look at each one individually. If you look at voter number 4, the voter lists a street but no house
No
number.
house number, right.
So that's the reason for that rejection.
Yep.
Same reason for voter number 5. It's the street but no house number. Voter number 6, there's no date.
Right.
There's no dates next to the voter's signature on the petition. Voter number 7, although the address now is updated in the voter registration system, but we did not receive that change of address from the voter until after the petitions were filed.
So therefore, that signature is invalid.
Correct.
Go ahead.
I think voter number 8, I think I'd have to have staff check on that one. Again,
The question I have with voter number 8 is, why would we believe that Tony Tubbs is Roger A. Tubbs, other than the fact that Roger A. Tubbs' middle name is Anthony? Tony Tubbs is a very well-known person around town.
Yeah,
And I don't think he's ever gone by any other name.
Well, I think if you take a look at the two signatures, you'll find that the two Tubbs look exactly the same.
I'm not seeing it, but
I don't
that's-
see that.
On number
I'm s-
8?
I do not see that.
Roger A. Tubbs, see Tubbs, T-U-B-B-S, Tony T. Tubbs, T-U-B-B-S. You know, that the two signatures are an example.
Yeah, it's Tony TNT.
They are not,
Tubbs.
from my view, the same.
I think
Well,
the Tubbs are the same. Again, this is what,
Tubbs, but
this
not
is what
the-
you
but
get
the
to in
rest
the,
of
in the,
it. Yeah.
this is very subjective, and that's what I've
Yeah.
never,
But the address wasn't correct. Is that the issue?
I think that I'd have to have staff look at. I don't know if it was updated at the time that the petitions
Can we
were
see what the current
filed.
address is, that he updated it?
We can
from?
have staff take a look at that one.
That would be a correction then, right?
That was actually one of the petitioner who, Tony Tubbs lives down the street from him. And his wife actually signed that petition with the same address above him, I believe, on the actual petition. So, but he
But we're
signs his
not
name as,
talking about his wife.
right, they're at the
We're
same
talking
address.
about the individual that we're looking at right now, Roger Tony
Yes, ma'am.
Tubbs. So I
And
don't
he
think
signs his
that's-
signature Tony TNT Tubbs because he's a boxer and that's his boxer.
Former
signature.
heavyweight champion of the world.
Yes,
I'm
sir.
not disputing the signature, I'm talking about the address.
Yeah, so
At the time
staff
that
is
he
going to
signed
check
it.
on that now.
Okay, at
Mr.
the time he
Effort's
signed the
checking on that.
petition.
so your question, Joe, is whether or not we rejected it because of signature mismatch or whether we rejected it because of address, right?
Right.
That'd be good information to have.
So staff is checking on that now. And then the last one, voter number 9, the last name on the petition does not match the last name that's on file with the board.
Now, somebody wrote in the board's name change there. Would we have done that, or would that be something that,
We might have done. Yeah, I'm not sure. That's
Sta-
not my, that's, no, we didn't do that. That's not my handwriting.
Staff would not do that.
they wouldn't write the name change in there?
I have no idea who it is, but I might understand that staff would not normally do that kind of thing.
So we're in the process of checking that right now, are we not, Ms.
10
Bowman?
and 10 and 11 are both wrong addresses, correct?
Correct.
And they're not just inverted numbers, they're wrong addresses.
That's correct.
And I think that's also true for 12.
And 12, yeah, and 12's the same way, yeah.
Mm-hmm. Shall we continue while we research that?
It may take a minute to research, so
Will you
yes.
continue, please, Mr. Grimes?
Sure. Let's take a look at these signatures. Then. I mean, focusing on the 9, and then I'll make sort of a group argument as to the rest of them. The Robin Jones does not have a wrong address. It just does not include the street address. The Section 2 of Article 12 requires signers to sign his or her name, address, instead of signing in ink or indelible pencil. You will also know that the address doesn't say their zip code, doesn't say their county. Presumably, they're Cincinnati, because that's up at the top of each of these part petitions. But the requirement to have an address is not understood to require a complete address. Matter of fact, I've never seen a complete address, because I don't see any signatures saying United States of America afterwards, although that's kind of implied. You know, the notion that they should have had, frankly, to help with staff, a more complete address doesn't mean they didn't have any at all. And this 4 and 5, which is the same issue, are sufficiently close to substantial compliance that they ought to be counted. The signatures match. There's no miscommunication about the street they live on. They can get their mail by addressing it this way, although it might take longer. It takes long enough as it is.
So, Mr. Bry, is it your position then that, I mean, if we were to find on those two in your favor, that would change substantially the way we do business here. I mean, we require an address with a number and have for a
Absolutely.
long time.
It would only change it when you're dealing with the Cincinnati Charter. It wouldn't change your duty to follow directives of the Secretary of State with respect to other items, and when 3501.38 applies directly. And there's a little bit of difference when we're dealing with a charter that expressly says you have flexibility, which is what the word substantially means. Than you are, or a charter that says you have to have your address, as opposed to a statute that says this is the type of address you have to have. So yes, you're going to have to change a little bit every time you're dealing with a charter community that has their own laws, but that doesn't mean that it affects anything else that you do with respect to general law when general law applies.
Except that the charter requires street and number.
And that's missing here.
You go ahead, Mr. Brown, whenever you're ready.
I'm looking for where it says it
It says
has,
it in
no,
three-
it doesn't say.
It says in 3A on the
Section 2 does not
form.
require street and
I'm
number.
sorry, did you, I think we're
Section
just getting.
3A requires street and number. It says the form shall be substantially as follows, and it says street and number clearly on it.
Section 3A does say street and number in the form that it says you're substantially the following form. Section 2, which requires address, does not require that. And Section 3 says that it shall be substantially as follows. I would respectfully suggest that you substantially given the address when you fill out the street and your name, and such a way that the mail will get to you, which it would.
When you indicate, because you've said this several times, and just from my point of clarification, it seems to me that you are defining, the word substantially. And whereas, from my understanding, the practice and the guidelines have always stated you must have a complete address, since we're discussing this one particular case. So therefore, if it does not meet the requirements, it appears you're trying to use substantiation in a manner to reflect your what you want versus what we follow.
Well, I would respectfully suggest that we all have to follow the guidelines of the Ohio Supreme Court. And what the Ohio Supreme Court has said repeatedly is that Ohio election laws must be strictly complied with unless they state by their terms that substantial compliance is sufficient. Now, Revised Code 3501.38 does not state that substantial compliance with 3501.38 is sufficient. And that's why your practice has been to strictly apply that statute, because that's what the Ohio Supreme Court says. But the Ohio Supreme Court has also said that when you have a charter provision, that's the one you follow and not general law. And here we have a charter provision that has substantially. So I'm asking that the board apply the substantial compliance rule that the Ohio Supreme Court has to the charter, even though the comparable provision, 3501.38 of general law, would not have substantial compliance, and therefore your normal procedure is, was, and will continue to be to strictly apply that.
Again, are you asking us to apply it based on what you define as the definition for substantial, when we are defining it and have practiced from under the Secretary of State and what the law says, the way it should be, the way we follow it? You know, so you're asking us to follow your definition of substantial?
I'm asking you to follow the Ohio Supreme Court and the Secretary of State's definition of substantial. And by the way, the tie-breaking decision that I talked about does talk a little bit about the Secretary of State's view of substantial. And it says when there are minor mistakes, you don't throw them out if you can figure out that people are qualified. That might not apply if you're dealing with a strict application statute, but it does apply when you're dealing with a provision of a charter that says substantially.
Again, according to your
According to the
frame of
Secretary of State,
reference.
according to the Ohio Supreme Court, according to pretty much every case that talks about the difference between substantial and strict compliance. Obviously, whether or not you use one rule than the other depends upon what the ordinance, depends upon what the statute, depends upon what the provision of the charter says. But it's pretty much been universal that strict compliance is required when you don't have substantially. It's not a word I made up. When they used this word in the charter, presumably they understood how the courts interpreted that word, and they wanted that interpretation, which is why they put it there.
Counsel, am I misinterpreting what's
No, you're just having a difference of opinion with counsel, that's all it is. I mean,
Okay.
Right,
the
and
the que- the
that's where much of
question,
this will turn on what.
yeah, the question is
substantial
going to boil down to what the board feels is substantial compliance. And-
thank you.
And, you know,
Thanks.
we went through this argument a week ago on the absence of affidavits from
affidavit,
anybody's
mhm.
petitions.
Okay.
We, and just for the record, we allowed, this board voted to allow that petition.
That we did.
And found it to be substantially compliant.
Correct,
not-
based upon 3A of the charter.
Correct.
Right.
So,
Yeah.
Thank you for that
well, and that's,
reflection. Continue, sir.
So I would say that 4 and 5 signatures on this exhibit substantially comply. 7 and 8 and 9, I believe, well, 7 and 8 anyway, involve address changes that I understand from staff were made after the filing, which means that it did not meet the standard of 3501.38. But it did meet the standard that's set forth in the substantially, the following, in Section 3A of Article 9 of the Charter of the City of Cincinnati, because they don't require that. They do require that they be an elector, and that's, I believe, in Section 2. And they have to be an elector at all times in order for their signature to count, but they were an elector at the time this was filed. They just didn't have the correct address here. And there's nothing in you know, and that as long as you're an elector, and you're substantially in this form, you know, that signature should be upheld.
which
So
two are those again, Mr. Bryan? I'm sorry, which two numbers are those?
I'm looking at,
Looking at
I
number.
skipped over Rudolfo Angustus, you know, where there was no date at all. And I'm focusing on 7 and 8, which
7 and 8.
is Stephen Redder and Roger Tony Tubbs. Now, obviously, we do have some directives, I believe by the Secretary of State, that states that derivatives of names should be
Sure,
accepted.
yes.
And that's kind of, yeah, I was a little bit surprised that difference between Tony and Roger Anthony Tubbs would be at issue, since the signatures seem to match.
Madam Chair, can
Yes.
staff
For
did
clarification.
research, and
Ms.
that was
Poland,
not the
yeah.
reason for rejection. It was rejected due to a wrong address at the time the petitions were filed. This voter was registered at a different address, and we received a change of address and processed that on March 1st to the Wyona address. So the
Thank
voter
you.
did not live at the address on the petition, or I'm sorry, was not registered at the address that appears on the petition at the time the petition was
Thank
filed.
you. Thank you for that clarification.
If I could add also, Tony Tubbs, we actually hand-delivered his registration to the board. Jim Burns, who was the elector on that petition, he was the one who actually went back out, got his registered at his address that he put on the petition, and brought it in. So we actually, his registration is with you guys.
But Ms. Poland, could you repeat what you just said? Because I think I understand that it's, at the time this petition was signed, this was not the correct address. And
At the
any
time-
correction afterwards is not relevant.
At the time the petition was filed, this voter was registered to vote from a different address. And then, I think Mr. Kelly is correct, we did receive an update and a change of address to the address that is listed on the petition, but that was received and processed on March 1st, which was well after the date that the petition was
Thank you.
filed.
Okay, thank you.
Is it your position, Mr. Bryan, we should count that one?
Yes, same as the prior ones, well, same as 7 and 8, then, that is the same argument, that the dating on 6 might be an argument, if there's no date, and there's supposed to be a date.
Isn't
maybe
that an alteration or a correction, though, even though it's not of the it's an alteration or correction of the board's records, not the petition? Is that your position?
Our position is that the charter requires them to be registered electors eligible to vote for mayor. The charter does not require that they be registered at the same address they currently live at. It basically said, when it talks about address, which is Section 3 and Section 3A, it says substantially in the following form. And I would suggest that even without, if 3501.38 applied, then it would be a change because it would be material. The change enables the board to verify, yes, these are the same people, at least as of today. They are registered in the same place that they signed the signatures. That was not the case, apparently, for these two individuals. when the petitions were filed. But the charter only requires that they be eligible electors, which they were.
In the city.
Which they are, in the city.
What if Mr. Tubbs was living in Anderson Township?
Then you can throw out the signature.
Do we know that?
Well, I'm not arguing that you should, or shouldn't, but I'm saying that since they've lived in the city both then and now, the difference between where they moved in the city is not treated in the same way as it would if they lived out in Madison Township.
Got it.
In other words, I'm willing to throw anybody under the bus that doesn't affect my client.
It's fair.
And I think even among the first 9, that adds 4 or 5 if you view, as I would argue, Rudolfo Angustus's failure to include a date as substantial compliance by extending the reasoning of the Secretary of State's tie vote. That would give us an additional 5. And then we have Amika J. Reed, Amika Thompson, who changed her name, same address. Amika looks the same on both sides. Did you have anything you wanted to say about that?
No, outside of the signature being the same.
The remaining signatures on Exhibit D and Exhibit E all have different addresses in the city of Cincinnati than the addresses of record as registered in the city of Cincinnati. But the signatures all match. And, our position is, and it won't be shocking or surprising to you, is that they should all be counted because the difference there is one that doesn't prevent them from being electors the day before, the day after, or as of the primary date, as long as they are registered in and live in the city of Cincinnati up to the date of election. They can update their registration information and still be a registered elector. That, I believe, satisfies the substantial compliance requirement, which is the only requirement there is in sections 3 and 3A of the charter.
Right, I don't mean to belabor this, can I go back to Mr. Tubbs and one more second here? So, there's no indication here as to where he used to be registered to vote the day that he signed, which would have been February the 6th. He's since updated it by Mr. Kaler's own testimony on March the 1st. But we have no indication of where he lived on that date, which again goes back to my question, what if he lived outside the city?
Well,
Do we know that information? Would we keep that historically or not?
What we would have is the last address he was registered to vote at.
Right.
Which we do have that information. It's 682 Hawthorne Avenue, 45205,
Which would be in the city.
in the city
but
of Cincinnati.
again, that puts an awfully large onus on the board staff to go back and look at your prior address. Just wondering if you have a response to it. This one's a little harder for me.
Well, I think that your point is well taken. Obviously, there's limits to hours in the day and there are limits to staff. And I would respectfully suggest that we're not dealing with 500 or 1,000 signatures. We're dealing with, half a dozen or a dozen, number one. And number two, when we are able to bring to the board's attention facts that are of record but maybe too voluminous to sort out, I think it's proper for the board to take those into account. But your point is well taken. I'm not suggesting that they had a duty to go above and
Sure.
beyond in terms of that.
Mr. Grimes, I just have a question. When you have a system where you have guidelines that you must adhere to, and we do that quite well here at the Board of Election. So if we're following those, and we have, especially in these situations that you have identified, I think it's, I don't see how I comfortably could even support what you're saying. So you're asking us to support what you're saying in spite of the fact that it's clear what the process has been and the procedure has been before today.
Here's how I would respond to that. I drove down from Columbus. I used the right lane rather than the ones that were headed north of the left lane. And that's a good thing because I don't want to break the law or get into accidents. If I were in England or Japan, it would be wrong for me to drive in the right lane, and I would be required to drive in the left lane, because that's the rule there. They have a different rule that's inconsistent with, and they have a different way of doing things, and that's what I should follow. What I would suggest is the guidelines that you're referring to, you should continue to follow when Revised Code 3501.38 applies. But you should follow the guidelines as they apply to that statute, not apply 3501.38 and assume it's the same as the Charter of Cincinnati, which allows for substantial compliance in ways 3501.38 prohibits substantial compliance. So when you're in the revised code lane, you are prohibited from giving flexibility. And when you are in the charter lane, you're required to give flexibility. That would be the difference I would suggest.
Madam
Your
Chair.
opinion, I'm thinking, if I'm in another country, I will follow those guidelines. But when I come to the United States, I have to adhere to those guidelines. So you're saying there should be flexibility if I create an accident. I could say, well, this is not the way we drive in Europe, but this is the way I'm driving here. That should be a substantial way, that I should be exonerated from any charges that could be pending because of my following the Europe guidelines versus the United States?
Well, actually, we were talking about two different jurisdictions, because Ohio has something called the home rule provisions of the Ohio Constitution. And the home rule provisions permit and authorize cities to have charters that supersede over general law, at least with respect to such things as local elections. And the citizens of Cincinnati have chosen to adopt a charter. So basically they're saying, for purposes of our elections, you're driving in Japan, not in Ohio. You know, and that therefore you need to follow our rules when we're talking about municipal elections in Cincinnati, but we're going to follow your rules everywhere else.
So did you have more to go in terms of signatures? Because I've lost track of the math a little bit.
Well,
Yeah.
I can help you a little bit with the
Yeah,
math.
that'd be
I
great.
think I went through the first 9. 3 of them were already vetted, so we're dealing with the other 6. And I think we had probably 4 or 5 or 6 of those. But we need 4. And then I did sort of a general argument about the remaining 10, 11, 12, and the others that are on Exhibit E, and basically said, as long as you know they're an elector, that should be good enough under the Cincinnati ordinance. But even if you we're a little bit more strict about that, I think of the signatures we've talked about, as long as you're doing substantial compliance rather than strict requirements of Ohio statute, if they apply, that we picking up at least 4 or 5 of signatures that get us over 500.
Mr. Bright, with respect to your Exhibit E, you have a number of voters listed here, and you're claiming all of these are electors from Cincinnati?
I am.
And who did the vetting of the addresses that are on the petition with respect to the electors from Cincinnati?
I came in and did all that work.
All right. Well, can you take a look at, it's voter number 18, number 17, under paragraph 7. He's paragraph C. And he lists an address that appears to be 28 Gall Terrace.
I'm sorry, what page are you at?
You're on page 10 of Exhibit E, top one, Terrence Reed.
Yeah, so the address on the top, I put in because that is the address that you have in the Board of Elections system. So.
So the 28 Gall Terrace is what we had in the Board of Elections system?
No. No, you had Fordham, the one on the top you had,
McHenry, isn't it?
Yeah, you've got
Fordham
McHenry
Place.
Avenue.
I believe.
Yeah, but when he signed the petition, he's listed 28 Gall Terrace.
Oh, I'm sorry, I may be looking at the wrong one. What is?
Terrence Reed.
Oh, I'm looking at Terrence Reed here. I've got 17, Terrence Reed, 28, Gall Terrace, and then above that, it looks like Fordham Place.
All right, well,
I believe that's the prior signature, I'm sorry.
Yeah.
yeah, and do we know where Gall Terrace is?
I do not know where Gall Terrace is. It would be in the city of Cincinnati, though, if I put it in here, I
I'm
believe.
going to disagree with you on that because I drive up Gall Terrace every day. It's in the city of Reading.
Oh, okay.
And that kind of goes back to my original concern earlier. If the day that he signed it, he told us he lived there, that's not one we can count, I don't think. What's the name of that street, Dave? Galter?
All Terrace. Gahl.
Yeah, but this is where he lives, that's what they're gonna go by. Right.
Anyway, that's one that's,
So that's obviously in red.
Are there any others we have? I don't believe so. Could you go through the other signatures on exhibit?
Talking to me?
Would we be able to check those, Ms. Poland? I did, yes. So when I went through, I made sure that they said active and then CI for Cincinnati. So that's what I checked.
Mr. Tubbs also appears on E, does he not? On Exhibit E?
Everything on D is also on E. E is not,
Okay.
E is a complete list.
Thank you.
And it shuffles them around a little bit differently. If we're using the
Right.
Would you continue, please, as we do this?
I'm sorry. One of the concerns we have, I mean, obviously, policy issues don't come into it unless you have flexibility. You know, if there's a strict requirement that you file by X date, file the next day because your grandmother got hit by a car, is too bad, but you're not going to be on the ballot. I mean, you know, because you don't have any flexibility about that. But if you do have flexibility, particularly in terms of the folks that are moving around, keep in mind that the folks that move frequently tend not to be as resource abundant as others in our community. That it may be that you're disenfranchising the very people that we need to pull out into our electorate, who may have a less stable family life. They may be moving more frequently. They may be in apartment complexes and move around. And if we basically say that that we are going to have a preference in Cincinnati municipal elections for people who have stable addresses and don't move a lot, and for people who don't have stable addresses and are required to, you know, and may not know the process of updating their registration dates until they get to the Board of Elections. To the extent you have discretion, and I think you do, I would hope that the board considers to exercise that discretion in a way that enhances voter involvement rather than excludes the very people that have been excluded far too much in the past.
Mr. Bryggen, back to my question. Thank you for that, by the way. Back to my question on math. So A and B would bring you to what number of signatures, assuming this board got to 460, which the board staff is agreeing with you about. So if we're at 460, A and B.
A gets you to 460, B will get you to 496. And,
Okay, so-
and therefore, we're, you know, we either do, if we don't get 4 more signatures, we're off the ballot. If we do get 4 more signatures, we're on the ballot. And so although we've dealt with 27 signatures in Exhibit E, and I focused on actually 6 of them, because 3 of them have already been entered into in Exhibit D. The reason for the focus is basically, although I think that they all should be admitted, because they all were and are electors, except for the one that was pointed out by your counsel. The ones that we focused on, if you apply a substantial compliance test, which I believe is, you're right, it's my opinion, but I think it's shared by the Secretary of State and the Ohio Supreme Court, that substantial compliance should enhance voter opportunity for choice and should enhance voter involvement for petitions. And I think that's the rule, and that, that even just focusing on the first few, we certainly would get to 4 or more. if substantial compliance is the test. If it's not the test, then I guess we're out of luck. But if it is the test, as I believe it is, then I think it's pretty clear that whatever the precise number is, we've got enough to get on the ballot.
Thank you.
Thank you.
Madam Chair, if there aren't questions for the witnesses anymore, I don't know how the chair wants to handle the question of executive session. I will at some point be making a motion that we enter executive session, as I do believe this is a quasi-judicial proceeding, and certainly with counsel present, although you haven't threatened litigation, it's always implied, right, counsel? But nevertheless, I'm going to at some point make that motion. It's the pleasure of the chair whether we hear first from Ms. Prather's counsel and do it that way. But that's, just wanted to be clear that I'm going to ask for executive session so as to hear more directly from our counsel.
I'd like to do it individually,
Okay,
and I'd like to, if that was going to be my pleasure,
thank you.
that we go into executive session to discuss the particular Mr. Kolak's.
And the correct terminology would be, was we're engaged in a quasi-judicial proceeding here, and we're permitted to retire to executive session. It's immaterial whether litigation has been threatened or not.
Fair
Thank
enough.
you.
I know
Thank you
both,
for that
both
clarification.
allow us to go into executive session. So
Can I ask one question before we do that? Mr. Bryce submitted a copy of the charter that did not have 3A in it. That is the actual section that's at issue here. I have a copy of the charter that has it in it. I think, in all fairness, that's what you should be considering, so.
Any objection, that's putting that as part of the record.
So I'm glad one of us did his homework.
It's actually in all of your packets.
3A as well, okay.
Thank you.
So
Roll.
with that then, Madam Chair, I'll make a motion that we enter executive session for the purposes we've already placed the record.
Second.
Roll call, please. Present, yes.
Aye?
Aye.
Thank you. We're going into executive session. Okay, we are, roll call, we are out of executive session.
I'll
Roll
move
call.
that we come out of executive session for
Thank
the
you.
record.
Second.
Roll call, please. Yes.
Aye.
Aye.
We have come out of executive session. The pleasure of the board. Discussion?
Well, I'd like to hear from the, our legal counsel
What would you like to hear?
about the substantial compliance as it relates to the argument the council made on the signatures he wants us to accept.
I think the thing the board has to remember is that the charter has specific requirements, state law has specific requirements, those must be strictly complied with. The section 3A that provides for the form of the petition is a substantial compliance section, and it's substantial compliance with the form, but not with the requirements, and that's all I have to say about it.
So I'll jump in, Madam Chair. We had, again, a robust conversation in our quasi-judicial proceeding in our discussion, and got good advice from our counsel, some of which he has just shared on the record. I am of the mind here to find substantial compliance and to vote to uphold the protest and allow Mr. Kaler to proceed to the ballot. That's going to be my position. I've articulated it sufficiently. But I believe that the affidavits certainly regarding the circulator statements on the petitions are sufficient for me, not as a correction, not as an addition under the statute, but I thought Mr. Bray made a I thought a compelling argument that is simply to be sure that there wasn't any fraud perpetrated upon this board. I never thought there was, but the affidavit certainly corrected any view that there might have been. Having the life experience that I've had, I'm bringing into this process. I know these things occasionally do occur, so for that reason, I find those under the A and B exhibits to be compelling enough to get us to where we need to be. And then, without enumerating each one, nor will I today, but I believe that there were sufficient signatures on the remaining group to qualify as substantially compliant, so as to, I suppose at this juncture, it would be to uphold the protest and to allow Mr. Kaler to proceed to the May primary ballot. That's my position.
Anyone else?
Is there a motion?
Howard?
No,
No, we're in discussion.
I believe that, I'm listening to the legal counsel, that it's not in substantial compliance as to the requirements. It's in substantial compliance to the form, but not to the requirements. It hasn't met the threshold. So I'm not in support of upholding the appeal.
Yes, Jim?
Madam Chair, just a question for legal counsel. What is the next step for us as a board?
Well,
You're voting today on the staff recommendation to reject Adam Kaler from the ballot.
Okay, so a motion has to be made.
That's where we're at.
It's not a vote on his protest. Shouldn't we rule up or down on the protest?
If you rule on the rejection from the ballot, you're doing the same thing. And that's, you can proceed how you choose to do it. Either motion would be appropriate, but that's where we're at. I mean, the reason we continued this and tabled it was to consider his objections to our findings.
I have, does that answer your question? I'm sorry.
Yes, Madam Chair, thank you.
Okay. Do you have is that up to me? Or have you made your comment?
Yeah,
For now, I have. Yes,
Okay.
thank you.
I do not, based on the evidence that has been presented and based on the facts that there were errors made, I am not in support, do not find that the arguments provided substantial information for me to support this, and so I am therefore rejecting it. And based on the numbers that we have, continue with the 460 as per staff calculations. So do we call it, put it to a vote?
I don't think there's been a motion made.
Motion? Do I hear a motion?
I move to deny the protest.
Any more I need a second. I second it.
In discussion, again, I will oppose the motion to deny it. I would, based on the information presented, and a close call, find substantial compliance, and I would vote, I will vote to deny, or vote to reject the motion, and I would allow Mr. Kaler to proceed to the ballot.
All those in, wait a minute, we've got a motion and a second. All those in favor of the motion? Aye.
Aye.
Anyone opposed?
I'm opposed, no.
Anyone abstaining? That motion carries. We reject it. Thank you.
As a point of order, you probably need to do a formal rejection of the candidacy at this point.
Need to put that in a motion?
Yes, sir. Yes, ma'am. I'm sorry.
Would you do that, please, Mr. Mallory?
Could you repeat that?
As a point of order, we just voted to deny his objections. What you need to do now is to vote to not to put him on the ballot, reject his candidacy.
Okay. I move to reject the candidacy of Adam Kohler to the ballot.
I second it. All those in favor?
Is there any discussion?
Any
Madam Chair?
discussion?
Yeah. Again, I think that Mr. Kaler has turned in sufficient signatures, substantially complied with state law, and much the same way that this board allowed Mr. Puravel to come in over an objection, I think that we ought to allow Mr. Kaler also to appear before the voters. We're taking away the voters' choice, so I object, and I will vote no.
Thank you. We've already said all those in favor? Aye.
Aye.
Anyone abstaining?
Well, my vote's no.
No? That motion carries. The ayes have it. Thank you. Next, thank you all. This has been interesting conversations thus far. You learn when I've always said, you learn when you lose sometime, and it's been a learning opportunity. Next, we're going to adhere to the agenda. The next item on our agenda, and I've got to find my page, just bear with me for a minute, is Ms. Prater is here, and again, we're conducting a hearing based on the reports of the staff with respect to the mayoral candidate petitions filed by Ms. Kelly Prater. The candidate and their counsel are reminded that pursuant to Ohio law, the board cannot accept or consider evidence that constitutes an alteration, correction, or addition to their petition or any of the part petitions they have filed. This is according to the revised code 3501.38.1. And has the staff had an opportunity to review the objections that have been filed by Ms. Prater?
Yes, we have. Regards to the first set of petitions that were filed on January 15th, those petitions staff reviewed, found 441 valid signatures. The candidate then withdrew on January 21st. On February 2nd, the candidate filed a new set of petitions. Staff reviewed and found those to contain 409 valid signatures. On February 18th of 2021, the candidate withdrew that set of petitions. On February 18th, the candidate filed another set of petitions. Staff reviewed and found 444 valid signatures. 6 of those part petitions filed by the candidate on February 18th, 21 were not the original part petitions. They were copies. The candidate, however, did submit those 6 original part petitions as part of the protest that was filed on March 5th. And you have copies of the protest and the petitions at your table.
Okay. Any more discussion? That's it? That's your report?
Correct.
Okay.
Sorry.
Is Ms. Prater present? And if so, are you represented by counsel? Okay. Then I'm going to ask you to present your case.
Madam
Sworn in.
Chair, she needs to be...
Sworn in, that's
yeah,
right.
she's gonna
Can
be
you swear in,
testifying.
please? Right hand.
Madam Chair,
Yes.
in the spirit of transparency, I am going to recuse myself because I was closely involved with assisting Kelly Prather review her signatures, and it was prior to me being on the board. But, you know, for the appearance of impropriety, I don't want any of that. So I think I'm just going to not participate in deliberations. I'm going to recuse myself from participation in that.
Thank you very much. I appreciate that. Thank you. Ms. Prater,
Thank
can
you
you
s-
continue, please?
Yes, ma'am. Thank you so much. To the member of the board, I'd like to say thank you so much for allowing me to present this testimony. My testimony is in regards to the processing of the signatures. I have three main concerns. It's not about individual signatures. It's more about how many signatures were actually processed. As Ms. Poland indicated, on January 15th, I submitted 939 signatures. Of the 939 signatures, 914 signatures were processed. On February 2nd, I submitted 1,000 signatures. Of the 1,000, 723 were processed, and on February 18th, I submitted another 939 signatures, and as she indicated, 820 signatures, actually 818 signatures were processed, and the reason given for the last 6 pages, which included 148 signatures not being processed, was because those were photocopied signatures.
Could you speak more directly into the microphone, please?
Yes, ma'am.
Thank you.
The reason I submitted copies is because, as I indicated, it was at the last hour. The pages that I had were wet, and so I made copies and submitted those. But if you look in the protest that I filed, they're the exact same signatures. They're the exact same signatures as the signatures that I submitted on February 18th. There's no alterations or anything. One of my primary issues with this is that of the 148 signatures that were submitted, 93 signatures were valid. As I indicated on March 2nd, when I submitted the first filing, I would come in sporadically and add the signatures, but I did not go through every signature individually to confirm whether or not it was a valid signature. With the other 2 submissions, I did come in personally. The second set of signatures, I verified 572 signatures were valid. The third set of petitions, I verified that I had close to 544 valid signatures. That is the only way I would have turned in the signatures. Now, I do appreciate Mr. Kohler's counsel in discussing the Ohio Revised Code as opposed to the city's charter. In this case, as it relates, because the city, we are in a charter form of government. As it relates to wrong addresses, the city's charter does not say that it has to be the address as it appears on the voter registration. It just says it has to have a name, it has to have an address, it has to have the zip code, and the date. So if you look, and I know that you all don't have all of my petitions, but there were approximately 200 signatures on each of the different filings that would have been deemed valid signatures if the wrong address issue did not come up. The other issue I have is that on the second set of petitions, which I withdrew, and I am being honest, I did withdraw those signatures. However, I only withdrew the second set of signatures, in my opinion, under pressure, trying to meet the deadline for the third filing. During the processing, after they processed the second set of signatures, I went to Ms. Poland and Ms. Crystal, and there were 140 signatures that I was disputing. I said, well, now these signatures are valid. I was not understanding that those are included in the protest. So Mrs. Crystal's response to me was, well, you have to take it up with the board. I listed those names individually, and a substantial amount of those signatures, they said that the address was wrong, but I went back and the addresses were correct. So had they processed all of my signatures, I would have had more than enough valid signatures. But then going back and looking at the wrong address issue, if you would, on January 15th, if they would have included the addresses that had the signatures that were correct, however, they said that the address was incorrect, I would have had a total of 710 valid signatures. On February 2nd, I would have had 621 valid signatures, and on February 18th, I would have had 700 valid signatures. So I think the issue here is the way that they process it. You know, in my opinion, it it just screams discrimination or a process of elimination, and I'm highly concerned with how the process was conducted. Again, there were a substantial amount of addresses or signatures that were correct. They had the wrong address, and they just threw those out. But even if the wrong address issue, wrong address was not an issue, I still had enough signatures to meet the threshold or to go beyond the threshold had they processed all of my signatures. So, and like I said, when I spoke with Ms. Crystal about the process, why 277 signatures were not included in the second filing, and then 148, well, in your defense, I won't say the 148, but to 277, her response was, speak to the board. So,
Okay.
and that is my testimony. And then they even processed the signatures twice, the second set of signatures twice. And I know, in conversation with Joe, he said, well, you withdrew the signature, so it's a moot point. Well, I disagree that it's a moot point because it's the overall processing of the signatures. I believe that the staff broke the law. Honestly, they broke the law when they decided how many signatures they wanted to process. On the back of the petition, it clearly has an affidavit of the Circulator Petitions, and it states how many signatures I want processed. On that second filing, I had between 23 and 25 signatures on each page that I declared that I wanted to count. And they determined, and I do have a breakdown of how many signatures, and for the sake of time, I didn't want to go through all of it. I'll just be brief. On the second set of petitions, on part petition 1, it contained 25 signatures. They only processed 10. Part petition number 13, there were 25 signatures. They only processed 17. On one of the petitions, it contained 25 signatures, and they didn't process any. So I'm not sure what the normal process is or why the staff would feel that they, can avoid or they can ignore that affidavit of the Circulator petition, which is, I'm declaring to a government organization that this is how many signatures are on there. So I don't know if you had an attorney present who said, well, we're not going to count this signature, or who decided to just exclude that signature. But had they processed all my signatures, I would have more than enough. And this is not even, considering the fact that there's an issue with wrong addresses.
Okay, thank you.
Pritchard, you did withdraw your January 15th filing and your February 2nd filing in writing, correct?
Yes, I did.
But-
And on the second filing, I withdrew it in writing, and I said I reserve the right to speak to the board about this and have them reconsider. I did make that statement.
Fair enough. So, but you are asking us to count that second filing, the 409, right?
Yes, I mean, if I had my choice, I would say count all 3 filings, because the first filing, they just threw out an entire page. They didn't consider one signature on one of my pages. So I'm asking the board to just, if you have to review all the signatures, that is what I am requesting. And honestly, one of my main concerns is that in this race, I will be the only woman. I stand chance of being the first African-American female to serve as mayor of Cincinnati. This screams discrimination, and I'm highly offended that I've never had this issue in the past. I've ran for multiple offices. I've never had this issue in the past, and now all of a sudden, I have not one incident, but 3 incidents where they say I didn't have enough signatures to process. As it relates to the photocopied signatures, I ran for the U.S. Senate in 2016. At that time, I submitted a complete copy of an original part petition, and then every other part petition was a photocopy. I was instructed or informed by the Secretary of State that that's legal, because basically they're just looking to confirm that my signature is correct, and they're just confirming that the signatures are the valid signatures. I did the same thing when I I submitted a petition to run for Ohio State Auditor. And for this to be an issue, regarding the last 6 pages, that could potentially take me over the threshold, I'm concerned. So again, I'm requesting that, although I withdrew the first and second set of petitions, I'm requesting that the board reviews all of my signatures and consider the flaws in the process.
Counsel, I have a question. According to petitions filed, when a candidate verbally and writes that they are withdrawing, that means all of those petitions are null and void. Am I correct?
Correct.
So therefore, you can't backtrack and go back to try to resuscitate those signatures.
That's correct.
Okay, so I want to just get that point clear, okay, and get it clarified. So then the next set of petitions on February the 18th, 2021, Ms. Poland, can you review that again for me, those signatures, and those ones that are valid and those ones that were not valid?
Yes, staff review found that 444 of the signatures provided were valid signatures. There were 6 part petitions that the board staff did not process because they are photocopies. They're not the original signatures. And according to, our elections officials manual, it must be an original signature of the elector.
And that's in writing, from the election manual?
That's correct.
Okay.
Well, to that, I'll say that it is an original signature of the elector. It is a photocopied signature of the elector. When I was speaking with Joe, he said, well, you're not supposed to submit photocopies, and he pointed to, on the part petition where it says that signatures on this petition must be written in ink or indelible lead pencil. According to Merriam-Webster's dictionary, indelible means that it cannot be removed. A photocopy, ink from a photocopy cannot be removed. It is the signature. So, I know I did submit copies of the petitions. I submitted copies of the petitions with my protest, and so if you can examine those, you'll see that nothing has been changed, but out of respect and just as a courtesy to the board, I made photocopies of the documentation so that you could read everything, so that everything would be legible. Because on the first 2 set of petitions, they said they were not legible. So, we're dealing with multiple issues here. We have valid signatures that were, a substantial amount of valid signatures that were excluded because of the wrong address issue. And we're also dealing with the fact that all of my signatures were not processed.
Okay, but had you completed your report, please?
Yes.
Okay. My understanding, and when you submit copies, especially when you're dealing with legal documentation and legal actions and as we're discussing today, photocopies are not accepted, nor are they to be valid for this particular situation.
And I think that's a point that needs to be clarified with the Secretary of State, because like I said, I did turn in photocopies of 3,000 signatures to the Secretary of State, or I would say 25, maybe 2,975 signatures to the Secretary of State when I ran for the U.S. Senate in 2016.
But we're talking about today, Ms. Prater. We're
Okay.
talking about the mayoral race. Candidate withdrew twice, 2 petitions, okay? And 2 petition filings. So that means all of those signatures are null and void.
Okay.
So now we're going to February the 18th, where copies were presented.
Okay.
And at that particular time, we all can make mistakes, and we both, Ms. Prater, can agree to that. But submitting the copies were not the original ones, so that, from my perspective and from what I'm hearing and seeing, would not be submittable. And so that's a concern that I have with that documentation, as well as turning in copies of petitions. Anyone else have any comments?
Has our counsel sounded off here about the,
I'm sorry.
is there anything else you would want to add for us?
No, I think we've.
The elections official manual, if we put that on the record, page 11-9, suggests you cannot turn in a photocopy, right? Just so that's clear.
That page indicates that it must be original signatures.
Original, correct, yeah.
Yeah.
From my understanding, if it's not, the word is not in there, photocopy is not in there, then it's not the law. Anywhere, I didn't see photocopy in any Within Ohio Revised Code 3501.38, I didn't see the word photocopy anywhere. And also in the charter, Article 9, CA, there's nothing about photocopy. And reflecting back on Mr. Kohler's counsel, what he said about the wrong address, again, my next argument will be that there were 2 pages, and I referenced this in my protest, 2 full pages that they didn't check any of those signatures. They just marked wrong address, without even looking to confirm whether or not those signatures were, the address was correct. And so for that reason, I believe that, if they would have taken a look at that, I would have had more than enough signatures. So even though, they didn't count the 148, and 93 of which were valid signatures, I had more than enough signatures that they just said wrong address to kick me, that would have not allowed me to get on the ballot.
Okay, well, I think from looking at January 15th, February the 2nd, those petitions are null and void,
Okay.
period. So let's talk about the February the 18th. It doesn't have to say photocopies, but if it says original, that means no photocopies.
I did not see original in the Ohio Revised Code.
What
I did
was-
not see
where was that?
original.
Did you just read, Mr.?
Yeah, can you,
I was looking it up on my phone too, so. I know you included that, didn't you, Sherry, or no? Is it not in there?
Yes, you should have the Chapter 11 from the Elections Officials Manual in your packet. This is
There
it.
it is.
It's under signatures, on
11-9,
page
yep.
11-9.
Let's see, 11-9 of the election official manual says, each signature must be an original signature of that voter. Yeah,
I conclude that
Can
the
you-
signatures were original.
Can you, let's finish reading that, please.
Sally, you said something I missed, I'm sorry.
The citing, when you look at each
Yes, footnote. Got it. Anyway.
Can you read that aloud, please?
I don't have the code section, I just see the footnote.
Here's what it says.
Yeah.
It says
Counsel,
signature
please.
shall be affixed in ink, and each signer may also print the signer's name so it's clear that they identify the signer's signature. It says they have to be affixed in ink, and we get the originals when you file them.
So it was affixed in ink, it was an original signature. I
But-
didn't write their signature.
Mike, I guess the concern that I have is that there were copies submitted versus being original petitions, and that, to me, is a point of discussion.
Yeah, it's a reproduction of the original signature, but it's
Right.
not the original signature. I think that would, and again, it's semantics, but unfortunately, we're bound by that, so.
Okay, do you, any other discussion? Do you have any other do you have a witness or any witnesses with you today?
No.
Okay. Okay.
Mr. Prather, I'm just going to say, maybe I'm saying too much here on a Friday afternoon, but if you just would have, you've got lots of signatures, just the way it was kind of handled, of withdrawing twice, and that just kind of threw us all for a loop. And, personally, I would love to find a way to do this. In my view, the photocopied part petitions are a problem, and that's probably why I'm going to support the protest. Or, I'm going to also vote to deny the protest.
And like I said, I spoke with Ms. Crystal about the 140 signatures that I listed that were valid signatures. And the only reason I withdrew those signatures because, I was rushing to meet the deadline. And I get it, but I think that, at best, just for the sake of my efforts, considering that I've turned in 3 times as many signatures as any of the other candidates, the board should review that third filing before you make a decision.
Looking at the third filing, and Ms. Prater, you, from my perspective, are a very seasoned candidate.
Yes.
And haste makes waste. sometimes. And I think in this particular incident, that's what happened. You know the process, you've been there, done that. But I think in this particular situation, you have to be accountable for the fact that you did not turn in original petitions, they were copies. I'm not gonna go back into January 15th, February the 2nd, because that's already done. And I just, there was an error on your part,
Yes.
and I support, I cannot support allowing you to be on the ballot because of that.
Okay.
That's
So
where I
what
am.
about the argument about the wrong address then? Since the addresses, the charter says that all you have to do is you have to have a name, you have to have a signature. I mean, the signature, the address, and the date. It does not say you have to have the address as registered with the Secretary of State or with the Board of Election. It does not say that. And so a substantial amount of that, the filing on February 18th, 256 signatures they just wrote wrong address. And the signatures themselves were valid. These were valid electors, and all of them lived within the city of Cincinnati.
Counsel, can you clarify that for her, please?
The bottom line is the charter is silent on that issue and state law controls, and state law requires the address that you're registered at with the board.
Okay, so even though the city is governed by the charter?
That's correct, because what the charter says about elections is that if the charter is silent on something with respect to the elections, the state election law controls.
So why would the charter law be silent on the issue of address?
It's silent on the issue of whether or not you're required to have the address as registered with the board. So the state law controls that issue.
Thank you. Thank you for that clarification. You know, I'm sitting here and I keep thinking about the right church and the wrong pew. Petitions were there, but they were incomplete. And that is an error, and therefore, based and following the state law as well as the charter to the best of our ability, I cannot support having you put on the ballot because of those errors.
Are you
And I
making a
support-
motion, Madam Chair? I'll second it if you are.
Oh,
It's
That's
all
right.
Oh, however you want to do it.
So what would be the next step if I want to contest it? And challenge the decision, the
well,
processing of the decision?
first of all,
You have to have a decision
Okay.
first.
I make a motion that Ms. Prater's petitions are invalid, there were errors, and will not be placed on the ballot for the primary election.
I'll second the motion.
Any more discussion? All those in favor?
Aye.
Aye. Anyone opposed? Abstaining? That motion
Abstain,
carries.
abstain.
And you abstained.
So
Okay.
what would be the next step if I want to challenge the board's decision?
I'll talk to you after the meeting if you want.
Yes.
Okay.
Okay, thank you.
Thank you, Ms. Prater.
Thank you.
I'm sorry, Madam Chair, Mr. Stevenson, is there another step we have to take? We've made two votes.
That motion was the last time you voted, her motion was more complete than Mr. Mallory's first motion the last time.
For a person who doesn't make many motions, that was a good one.
Thank you, sir.
Our chair shouldn't be making the motions.
I know, I'm a little, that's a, yes.
Anyway.
Okay. Let me filter through all this paper. Someone give me my agenda. Your agenda. Thanks. Next on our agenda is, basically, is certification charter amendment. Ms. Poland.
Yes, the board has one additional charter amendment to certify to the May 4th, 2021 primary election. This charter amendment was filed after your last meeting. This is the City of Cincinnati Charter Amendment Affordable Housing Trust Fund. There is a copy of the ballot language in your file. I think the ballot language was submitted to the Secretary of State's office and approved. But as I think the board is aware, we were recently, the board was sued on this topic in the Ohio Supreme Court. So that's where we stand regarding the charter amendment.
So point of discussion, we as a board are we took the amendment, the ballot language, we submitted it, we approved it. I'm just trying to put together a paper trail. From there, it was sent to the Secretary of State, who approved it as well.
Yes, staff received the proposed ballot language from the city of Cincinnati as part of their ordinance that was filed late last week. Staff then took the proposed language from the ordinance and submitted that to the Secretary of State's office for approval. And we received that approval from the ballot language, and now the amendment is before the board to certify this amendment to the May 4th, 2021 ballot.
Question, pleasure, discussion.
Again, this is, there's already action in the Supreme Court on this question, so at this point.
There is, and frankly, there wasn't, there was an announcement by the Supreme Court of a briefing schedule, but I've received no orders, and I just checked a few minutes ago in terms of telling us to stop what we need to do pending their decision. If you certify it to the ballot, I would certify it to the ballot pending the decision on the Supreme Court on ballot language.
Is it your advice that we do so?
Yes.
And I think there's counsel present, right, for both sides or one of the sides? No?
City.
Right?
Oh, yes, please. Can you just share with us your name?
Yes. My name is Emily Smart Warner. I am Deputy City Solicitor for the City of Cincinnati.
Thank you.
I want to be quite brief. We would ask the board to approve the ballot language that is before you because we think that that accurately reflects what the charter amendment does. If it would do if it is passed, and that language allows the voters to know what they're voting on. So we would ask that you approve that language, and I'm here to answer any questions you might have about that, but I want to be respectful of everyone's time as well.
I don't have any questions. I'm prepared to make a motion, Madam Chair, that we approve the charter amendment language pending any additional guidance from the Ohio Supreme Court.
Second.
I have no questions as well. The motion's been made and second. Any more discussion? All those in favor?
Aye.
Anyone opposed? That motion carries. Thank you very much.
Counsel, thanks for your patience today.
Thank you. Okay, next on our agenda is a resolution authorizing execution of equipment delivery contracts. Ms. Poland, you want to share with us give us an update on where we are with that?
Sure. Our current contract expires at the end of this month. Staff did issue an invitation to bid. We received one vendor that provided a bid, and this resolution would give the deputy director and I the authority to negotiate and execute a contract.
I'll move adoption of the resolution, Madam Chair.
Second.
Any more discussion?
Yeah, what's the value of the contract?
On an annual basis?
Yeah.
On an annual basis, I don't have that right before me. It is a per polling location charge. I just didn't bring it with me in the room. It's something I can give to you.
You have an aggregate cost, or you just?
We do in the draft contract. I just don't have it with me in my
Okay.
file, but I can get it to you after the meeting.
Okay.
Is there a concern?
No.
Okay. Okay, motion's been made and seconded. All those in favor?
Aye.
Anyone opposed or abstaining? That motion carries. Thank you very much. Next on our agenda is full approval of full-time staff appointments. Sally or?
I'll be presenting this one. These were openings that we had, 2 Republican openings with the Board of Elections, where we wish to appoint Kelly McGowan to Elections Coordinator in the Operations Department, and Jay Hellebush to Precinct Election Official Training and Outreach Supervisor in the Absentee Voting and Precinct Election Official Department. They would both start on March 22nd.
Fantastic, okay. Need a motion?
Move to improve the 2 staff appointments.
I'll second, and again, I've always enjoyed our bipartisan approach here, where the motion is typically made by the other party, and I do appreciate that. Both of these individuals met with myself and the director we think they're wonderful additions to the board. And although we're losing some outstanding people, but we think we've got two new outstanding choices. So I'll second the motion. Thank you.
Okay, any more discussion? All those in favor? Aye. Anyone opposed? Anyone abstaining? That motion carries. Is there any other business before us?
Just to let the board know that there's an updated organizational chart in your packets, as we have had numerous personnel changes in the last few months.
Okay, we got to keep up with that. So therefore, our next meeting, board meeting is Tuesday, April the 13th, 2021 at 8:30 in the morning. I'd like to entertain a motion that we adjourn.
I'll move that we adjourn.
Second.
Any more discussion? All those in favor? Aye.
Aye.
Anyone opposed? Anyone abstaining? That motion carries. Thank you.
Thank you.